Thank you. Okay. Yeah, is that okay? Okay. Ready. Good afternoon, everyone. My name is Robin Vasquez. I'm the owner of Estate and Guardianship Management Services. It's a company in Punta Gorda, Florida, who has been providing services to the senior population in Charlotte, Lee, and Sarasota for the past 21 years. Today, we're here to talk to you about guardianship. Go ahead. So the first question is, what is guardianship? It's kind of a strange animal, and many people have heard about guardianship, but it's a very strange concept to understand, especially in the United States of America. But guardianship is the legal process wherein an adult individual is appointed by the court and assigned to perform the legal rights or acts on another person that has been proven to be incapacitated. Guardianship is intended to protect persons who are unable to care for themselves or their property, as well as those who are vulnerable and at risk for abuse, neglect, or exploitation. In Florida, guardianship is governed under Florida Statute 744. It's a court-supervised process in which the court appoints an individual to make decisions and to act on and behalf and for the benefit of another person who is unable to act for themselves. In guardianship, there's a process for someone to establish a guardianship. It starts off for someone to must file a petition with the local court where the alleged incapacitated person lives. Until they're deemed incapacitated, we refer to them as an alleged incapacitated person. The process is completed. The petitioner hires a local attorney to draft the petition. The petition will name the alleged incapacitated person's name. It'll name what their alleged disabilities or incapacities are. It will list the petitioner, the person who is alleging that this person lacks capacity. It'll also list addresses of next of kin or other interested persons who may provide evidence to the court regarding the incapacities, to give the court more information so that they can base their final decision on as much information as possible. So once the petition is filed, the court will appoint an attorney to represent the alleged incapacitated person. In the United States of America, everyone's entitled to due process, and that attorney is to make sure that the alleged incapacitated person's rights are protected throughout the guardianship process. Once the court-appointed attorney for the alleged is appointed, then the court appoints a 3-person examining committee. The committee is made up of 3 medical professionals, one which must be either a physician or a psychiatrist. Each medical professional will examine the alleged incapacitated person. They will file a report of their findings and submit it to the court. The judge will then conduct an adjudicatory hearing where he will determine whether or not that person is in fact incapacitated. If so, to what extent is the person incapacitated? And then, if required, will appoint a guardian. So there's a number of different types of guardianships. For the purpose of today's discussion, well, a little bit about the different types. There's pre-need, there's natural, there's VA, there's voluntary. But today I'm going to focus on emergency temporary guardianships. Those are referred to as ETGs. Limited guardian, which could be guardian of the person, guardian of the property, maybe a little of both, and then a plenary guardianships. And that's when a person has been deemed to be totally incapacitated and needs help in all aspects. So let's talk about emergency temporary guardianship, the ETG. That can occur prior to a determination of incapacity. a court can appoint an ETG, an emergency temporary guardian. As I said, it occurs prior to a finding of incapacity, and in order to appoint an ETG, the court must specifically find that there appears to be imminent danger to the physical and/or mental health of the person, a high likelihood that their safety is in jeopardy, or that a person's property is in danger of being wasted, misappropriated, or lost unless another person steps in and takes immediate action to preserve their property. The authority of an ETG expires 90 days after the appointment, or once the person has been deemed to be incapacitated, or if they have found to have capacity, then the ETG would be terminated at that point. But it can last up to 90 days. Then we have a limited guardianship. A limited guardian can only exercise the rights and the powers specifically designated by the court after the court finds an order entering the person does lack capacity in some areas. For example, so a person could have the ability to take care of themselves, but they can't manage their finances. I have a recent case. I'm currently emergency temporary guardianship for a gentleman who lives in Lee County, and he is alert, he is oriented, he maintains his own home, he swims laps in his pool every morning, he walks, he talks to the neighbors. Probably his greatest physical deficit is his hearing loss. However, his wife died a couple of months ago. She handled everything. She handled their investments. She handled their bill paying, their bank accounts, all of those things. He is originally from Germany, so there's some cultural and language barriers that he still, after being in this country for so many years, still has to contend with. And so I am the emergency temporary guardian of his property, but he does all of his other tasks to himself. But I manage his finances. I make sure his bills are being paid. He and I talk about his bills and whatnot because he has the capacity to understand. He just can't actually do the follow through of what it takes to go to your mailbox. He can go there and get his mail, but once he gets it, what does he do with it at that point? So that's a limited guardianship. They'll allow the guardian to have jurisdiction and to have authority over certain areas where a person needs that extra help. And finally, there's a plenary guardianship. And as I said, a plenary guardianship is when a person has been deemed completely incapacitated, totally incapacitated, and all delegable rights of that person is passed on to the guardian. So those are the different types of guardianships, a few of them that there are. Now, I just talked about delegable rights. There's a number of rights that can be removed from a person. So when the examining committee comes out to meet with someone, then they have their report and they check off the areas that they feel a person lacks or has the capacity. So if you're looking at a guardian of the person, the rights of the person are the right to marry, the right to vote, the right to personally apply for government benefits, to have a driver's license and operate a motorized vehicle, the right to travel, to seek or retain employment, to make medical decisions, to determine their residence, and to determine their social environment. And then the rights that can be removed under the property is the right to contract, the right to sue and defend lawsuits, and the right to manage or make any gift or disposition of the property. Now, if the person is found to be incapacitated and it's not a plenary, then the court must enter the order that includes and specifies what rights the person is incapable of exercising. The rights that can be removed and not delegated to a guardian are the right to vote. So a guardian can't vote for anybody else. I think that's probably a good right that's not delegable. the right to marry. Guardians can't marry for them, which I think all of us would agree don't want to marry for anyone else. So the right to have a driver's license. We can't drive for anyone, or we can't get a license under their name and hold it in our possession. And the right to seek or retain employment. We can't go in under a person's name and work for them. Now, rights that can be removed and that it can be delegated to the guardian are the right to contract. So we can sign contracts, whether it be with home health agencies or property management companies or repairmen or whatever it may be. We have the right to sue and defend lawsuits. Prior to suing anybody, the guardian must obtain court order before doing that. One situation I was in a couple of years ago was the wards, once a person's incapacitated, they're referred to as the ward. The ward's daughter, under a power of attorney, deeded the ward's home in New Jersey to herself, to the daughter. The ward's in Florida with the other daughter. She required assisted living facility, and we needed the asset, the house, that was valued at about $350,000 to provide for my ward's care. So we spoke with the daughter because what she did under the power of attorney was wrong, and it was illegal, and it was all kinds of things. And she said that she would give us back the house to help pay for her mom's care, but then she didn't. So ultimately, I had to file a lawsuit against the daughter, and I had to ask the court for permission to be able to do that. And the court granted the permission, and ultimately we did get the house back for the mom, sold the house in New Jersey so that we would have the assets to provide towards her expensive care in Florida. So, again, rights to sue and defend lawsuits can be delegated. To apply for government benefits can be delegated to a guardian. So I can go to Social Security and I can apply for benefits. I can go to the VA. I can go to different long-term care companies, whatever it might be, and to apply for some benefits that my ward is entitled to. I can manage property or make, I'm sorry, look up there. As far as the property management goes, that again is employing people, taking care of it, paying bills, taxes, making sure it's insured, all of those types of things. I can also determine a ward's residence. Can they stay at home with caregivers in the home? Maybe they don't need caregivers. On rare occasions, we have wards that go into guardianship for different reasons, and they are at home without anyone, with minimal supervision. But regardless, if they cannot maintain at home, then we have to make the decision on where the best residential setting is for that person. We can consent to medical or mental health treatment on behalf of the ward, and we can make decisions about their social environment or other social aspects of their life. So, for instance, if there was someone that was detrimental to the ward, that was trying to take the ward to banks so that the ward could withdraw money and give it to that person, those are times we would step in and say, this isn't really a good social situation for the ward because someone else is trying to take advantage of them, and our job is to make sure that they're protected. So the next one is, who can be a guardian? Sometimes they say, who would want to be a guardian, right? The court will appoint a person who is fit and proper and qualified to act as a guardian. It can be any resident of the state who is sui juris and 18 years of age or older. It can be a non-resident of the state if he or she is related by lineage, legally adopted child, or adoptive parent or spouse. And there are disqualified persons. Now, I think this is one of our slides that have a mistake. Disqualified persons are convicted felons, service providers, or their employees, creditors of the ward, and those who have been judicially determined to have committed abuse. And what that should say is, and those who have not been judicially determined to have committed abuse, neglect, or abandonment against a child. So when you're serving as guardian, you do have to go through a professional, a credit background check, a criminal background check, and you are disqualified, certainly, if you're a felon. The court will give consideration and preference to the person if they are related by blood. They have first priority over a professional guardian or another person. In addition to that, the court will also give preference if the person has relevant education, a business experience that is coincides with the nature of the services that this person needs. They will also give preference to any previously designated standby or pre-need guardian or person that the guardian has previously expressed a preference to. And we've run into situations when especially when there's children and there's one child wants to be the guardian and the other child, they're at odds. And if the ward makes a preference and can communicate what that preference is, the court will look at that person that the ward prefers, and if appropriate, will appoint that person. So I think they do try to follow what the ward's wishes are. Okay, let's talk about who can be a guardian. No, I'm sorry, just signs. Let's do signs someone may need a guardian. They lack good judgment on how to keep themselves safe. They're unable to attend to activities that they used to attend to, preparing meals, grocery shopping, maintaining their home, bathing, or dressing themselves appropriately. I had one person, the examining committee member, said, well, they can dress themselves, and the facility said, yes, but they're putting on a wool suit in the middle of August and walking outside in 110 degrees. So we want to make sure that they can do it appropriately and not get a heat stroke. Other signs that someone may need a guardian: they can't reliably take their own medications. They forget to take them. Gets lost in places that were once very familiar to them. And a lot of these things I see this gentleman in front looking at you. These are when you're consistently. We all forget things every single day. I forget to take my vitamin, and I forget where I put the keys and those types of things. But if it's consistent and it's negatively impacting your well-being, then that's when it becomes a problem. If the person gets lost, does things around the house that are dangerous. They are leaving burners on, those types of things. One thing we see a lot down here, I do at least, is responds to mail or calls that are obviously scams. I remember not too long ago, I was driving with a client. I was driving her to a doctor appointment, and she answered her cell phone, and she'd go, hello, hello, hello. And I said, do you need help? She goes, talk to them. It's the Social Security office. And I said, the Social Security office never calls you. So I said, but it was kind of funny that, you're right, the IRS, they want my Social Security number. No. But I do see that one quite a bit out here. Insists on driving. That's a tough one, even though it's not safe. One of the rights, as we talked about earlier under guardianship, is the right to drive. It's so difficult, and especially if you have someone that has some dementia and they don't see there's nothing wrong. I've never been in a car accident, they'll say, and I get it because that's such a loss of independence. But sometimes, the court has to make the decision what's safest for the ward as well as others in the community. Has become very forgetful, misses appointments, forgets events, late with paying bills or doesn't pay bills. A lot of times I'll get a new ward and I'll say, oh, last week, I get them this month and realize taxes weren't paid in November. Things like that. Their homeowner's insurance had lapsed. That's a big one because that's not even a monthly, typically it's on a monthly payment. So people forget that. They don't open up the envelope, and next thing I know, we're in hurricane season and we have no homeowner insurance. So it's up to my office to make sure that we get that because it's our job to protect the ward's property. No longer able to balance the checkbook. That's a big one too. I had a gentleman who, his background was an accountant, and when I caught him, he had about 7 bank accounts, and he loved balancing his bank accounts. That was his entertainment. And one day, he wasn't guardianship, I was power of attorney for him. One day he came to me and said, Robin, this just isn't fun anymore. And he was having trouble because he was becoming forgetful, and with all the new changes in bank statements and automatic, electronic deposits and electronic debits, it was becoming too much. So I said, okay, let's consolidate. Let's get rid of the rest of these. Let's pick a bank, do one, and then he could manage that one bank account for a period longer before I had to step in and start to help him more actively. So, okay, so those are some of the signs that someone may need a guardian. I think you all pretty much know those. So let's talk about knowing the roles and responsibility of the guardian. First and foremost, a guardian's an advocate. We must always keep in mind is what is best for the incapacitated person. They are number one. They are why we do what we do. If a conflict arises with the ward's family, maybe a facility, or any other entity, the guardian must determine what is in the best interest for that incapacitated person. And long story short, guardians do not win many popularity contests. We're the ones that come in and make people do their job many times. We're also a surrogate decision maker. When a decision needs to be made, it's our job to evaluate the issue, research options, and then carefully select the option that is in the ward's best interest. The guardian should use substituted judgment whenever possible and make decisions that are in accordance with the ward's wishes, beliefs, and lifestyle prior to the incapacitation judgment. It's not our beliefs and our feelings. It's what would that person do if they were able to do it for themselves. And as long as it's safe, that's the really what we need to follow as a surrogate decision maker. We're also a coordinator and monitor of services. These can include medical services and property management. While implementing the decisions, the guardian must research available resources in the community, checking prices, what their reputation is, things like that. And then we can employ these service providers. If there are problems with the services, it's then our responsibility to resolve the issue, or if possible, terminate the service provider and find someone new if they're not providing the appropriate service that was agreed upon. So we deal with, skilled nursing facilities, assisted living facilities, private home health companies, skilled Medicare-provided home health companies, mortgage companies, insurance companies. I try to tell people, think of all of the things you do each day to manage your life and what you have to do on a monthly basis. That's what we do, but we just do it for other people. We also have to be a financial planner and an asset manager. When we're guardian over another property, we're responsible for the prudent management of the person's estate. We must control income, we must pay valid debts, we must sell property, manage investments, and at times apply for government benefits. So a plenary guardian is responsible for taking any steps necessary to protect the personal and financial well-being of the incapacitated person. A guardian owes a fiduciary duty to the ward, meaning that the guardian must always act in the best interest with undivided loyalty to the ward, avoid transactions that could cause a conflict of interest, and make all decisions with care and prudence. Again, we must act in the best interest of the ward. We also make efforts to include the ward in decision-making when possible. I met with a gentleman earlier this week, and I'll be paying all of his bills, but he's able to understand what he wants. So I'm going to include him in it, although ultimately I'm responsible for those decisions and must make them. It's his assets, and he should be treated with respect and dignity and be involved in those decisions if he's able to, which he is. We're also expected to consider the ward's known and reasonable desires and personal values. And that's what I talked about earlier, about knowing your ward so that the choices you make are in accordance with what that person would have done if they're able to. We make the decisions as a prudent person would, in similar circumstances would. And although we are ultimately accountable, and unless we are allowed to hire professionals to help us fulfill our duties, and that includes attorneys, CPAs, physicians, mental health providers, rehabilitative therapists, whatever it needs that we need to do to fulfill our job. Okay, so and I know I'm getting a little short on time. In addition to what we, the duties and the roles and the responsibilities to the ward, we also have a duty and responsibility to the court. The court has appointed us. And so in addition, there's many administrative duties that we must comply with. And one of them is reporting to the court. So unless the court orders otherwise, we must submit an initial report, an initial plan of the person. We must tell, that report must talk about the ward's well-being, the ward's growth, the health needs. What medical treatment are we going to provide for the coming year? What rehabilitative treatment? What mental health treatment? Anything that about that person's plan of their person, the court wants to know about. And then we complete those plans on an annual basis or more frequently if the court orders that. In addition to the plan, we have to do an accounting. When a person becomes a guardian, we have to do a verified inventory. We have to marshal all of their assets and report to the court, this is how much money the person has, and this is how it's held. So every single account needs to be itemized and listed on that inventory. Once we must set up and keep complete financial records. We must detail in our report all income, disbursements, liabilities, capital transactions, opening and closing balances of all of the ward's accounts. And those are submitted to the court also on an annual basis or can be ordered to done more frequently by the court. But normally it's an annual basis for our accountings. So we've got some, basically our joke at the end is responsibility of the guardian, everything. If we just consider that everything is our responsibility, we can't go wrong. We do have a court auditor now. This has been implemented in recent years in the court system, and it's not a bad thing. But the clerk of the court now has a guardian court monitor who does oversee all of the paperwork, petitions, orders, and reports that are submitted to the court. So it's another set of eyes on those documents, and that it should be so. We're dealing with vulnerable people, incapacitated people, so we need to protect them. So before we close, let's talk about quickly a few alternatives to guardianship. What you need to know is guardianship is a last resort. I kind of joke because I'm a professional guardian, but we really don't want anyone to need my services. We don't. It's a last resort. It can be an expensive process. It's a public process. And it's when a person's civil rights are removed by the court. They're removed to protect the ward, but nonetheless. So it is highly recommended that a person execute other estate planning documents as a favorable alternative to guardianship. There is a saying that goes, if you don't have a plan, the state of Florida has one for you. The problem with this, it might not really be what your wishes are. It's a plan, but it may not be what your plan is. So why not plan for the event of incapacitation? We all hope we are never incapacitated, but if it does happen, there's other things we can put in place. The first is a durable power of attorney. Durable power of attorney, we also call it a DPOA. The person who creates it is the principal, and the person to whom the power is delegated to is the agent. Okay, durable powers of attorney are only good during a person's lifetime. They can be revoked at any time as long as the principal has capacity. Another thing is the designation of healthcare surrogate. So I think. Oh, can you just switch it? Sorry. There you go. Okay, there you go. So, yeah. Okay. Sorry, DPI, no, I'm running out of time. Legal document delegating authority from one person to another can include the sale or maintenance of property, access to financial accounts, signed contracts. Powers can be limited depending on what the document specifies. That's a conversation for you and your attorney. And the principal must be competent for the document to be valid. Okay, the next one is healthcare surrogate. Document names another person to make medical decisions if you are unable to make them for yourself. It can include instructions on what you want done should you be terminal in a vegetative state. It remains in effect again until revoked by the principal. These are documents that can be revoked, that can do everything a guardianship can do with half the expense, and also you've made the choices. And then the last one is trust administration. That a trust is a legal document to hold property in a fiduciary relationship for the benefit of the named beneficiary. The living trust can serve the grantor during your lifetime, but it can also pass on, take care of your estate after your passing and those of your loved ones. The assets placed in the trust will not go through a probate. They'll just be a trust administration. Also, trusts can be amended or revoked during the grantor's lifetime. And I'm just got the 1 minute sign there, so I want to thank everyone very much for being here this afternoon and give you a little time if anyone does have any questions to feel free to ask. Okay. Well, if you do a trust, you would do a trust, and you're the grantor of that trust, and then you're typically the trustee of your trust, and then you're going to have a successor trustee. So should you become incapacitated and say that I was named as your successor trustee, but you're alive, then I can step into that trustee role, and your trust is going to have terms. You have to be deemed incapacitated by 2 physicians or 1 physician, whatever you and your lawyer decide. But the point is that I can then take care of your assets, provide for your care, do everything with your trust that you would do if you had capacity. And it's according to your wishes and your terms. Then when... No, okay, yep, I have to. So then at that point, the trust would be administered and it would be distributed according to your terms. So it might be paid out right away to the beneficiaries. It might say, I have a grandson who's 25 years old and I don't want him to have the money till he's 30. The trustee would do whatever that trust says. You, sir, you had a question? Most of the time, my referrals, many come from attorneys. I'll have an attorney will sit with a client, and they will do their estate planning, and they'll. Oh, no, okay. And yeah, I'll talk.